Ah, okay, we are live now. Okay, that's great. Yeah, so good evening, sir.
Very good evening.
Yes, sir. So,
Yes, well,
yeah, so as we started streaming this live onto Facebook, by the way, so, so let me hit record on this computer. Okay, so we have both the things happening alternatively. So let's jump into understanding the patent process for startups, sir. With respect to the series of frequently asked questions, again, many people keep asking us the same questions, mainly for navigating the complex world of patents, mainly in India. So, as we have tailor-made this particular podcast event, so let's jump into what are the crucial first steps in the patent process for startups, and how to file a provisional patent application, or what are the requirements for completing the patent application, and drafting patent specifications with technical and legal expertise, understanding the patent examination process, and responding to the objections. So the pre-grant and pre-grant and post-grant opposition process, and how to expedite things and the costs involved, and how to attract investors. This is again commercialization, or how to cash the patents, or strategies and benefits. So let's jump in, sir. Thank you so much for another episode. I'd like to thank Shravanti, who is tuning in live. She's also an attorney at law. Shravanti, if you can hear us, just give a thumbs up. And if you'd like to speak, just raise your hand so that you can join the speakers panel. Okay, sir, you can allow her to speak. And as Shravanti comes to the speakers panel, let's jump into the first question for the evening, sir. You can approve her request to join the speakers panel.
yeah, I did.
Okay.
I think she is with us. Yes.
Good afternoon, sir. May I speak?
Yeah. Good evening, Shravanti garu. Please go ahead.
Yeah, thank you, sir. Actually, I am new in this trademark field. I am regularly following your videos and the events. Thank you for this opportunity. I would like to know that how to build how to build career in IP sector, sir.
Good question, Shravanti. You are a law graduate, right? So you worked somewhere previously,
Yes, sir.
not
I
into
worked.
IPR, maybe other field.
Yeah, into IPR I worked into 6 months. In other field, civil and litigation, I worked into 1.5 years.
Okay. So you are 2 years old, advocate, registered advocate. Okay.
Yes, sir.
Yes. Yeah, IPR. You have science background as well.
No, sir. Only from commerce background.
Okay. So yes, rightly, copyright or trademark you can practice. So trademark law or copyright law or both, and as well the patent law as well. But yeah, you cannot uh, um, write the patent agent exam or maybe qualify it because like you don't have a science background. But no issue. So overall, you can practice in IPR. So you can specialize in trademarks and copyrights. With another 1.5 years, 2 years actually, if you can work with someone, yes, you can learn the complete life cycle of trademark registration, and then you can actually know about, or you already know a bit of procedure to file a to send a cease and desist notice, or maybe to file a dispute, case in terms of patent or trademark infringements. So first, you need to understand the prosecution, the whole life cycle, what happens with trademark registry, what happens with patent office in related to patent applications. So it will take another 1 year, 1.5 year if you are if you are interested in actually pursuing this as a career as an IPR attorney.
Yes, sir. I am
So we'll
interested
jump in.
into pursuing an IPR attorney only, sir.
Yeah. So you can definitely follow us, follow our events, or we will check like if we can accommodate in our team as well. Yesterday we had discussion like you actually sent a text to one of our associate, Hari.
Yes, sir, Hari. Yes, sir.
Yeah, we'll look into it. We'll see if we have an opportunity. We'll definitely let you know.
Thank you, sir.
Yeah, we'll quickly move because like we are doing it today. We thought of actually discussing about the patent process and what a startup need to know to file their patent applications. Yesterday, day before, we discussed about the crucial why IP is crucial for startups and how can they uh, build and as well monetize in terms of their valuation. So we're now actually jumping into what exactly patent application, how to file and all. Raj, yes,
Yeah, as
Shravanti
Shravanti,
will be
yeah,
with us.
yeah,
Yes.
yeah. As Shravanti Garu is here. Probably I'd like to. It's not an interview, Shravanti ji. Uh,
Yes,
but
sir.
but we'd like to give it a shot. We'll see. Anyway, Srinivas sir will give the best answer. But I would like to give it a. I would love to see if you can give it a try as well. So when it comes to the first step in the patent process for startups in India, what is that would be? Like, what is the first step in the patent
Uh,
process for startups in India?
in patents, I don't know.
Not
I
only in
don't have.
India, to plan if someone is having an invention and they are thinking about actually filing a patent application, then what is the first step they has to do, or they uh, has to consider doing?
They need to, in my opinion, they need to write patent exam and they have to take patent attorney code.
Yeah, apart from that, you've done with your patent exam or the patent course and all that. But again, what would be the first step if you are already somebody who is delivering the patent service? What is the first step in the patent process for startups?
Oh, sorry, sir, I don't know exactly.
Okay, great. I mean, I was waiting for that answer. I don't know, or people don't accept the fact that they don't know. Over to you, Srinivas sir. What is the first step?
She knows the answer, I think, but yeah,
Maybe
it's the
she's unable to
search,
put it
patentability
across.
search
Yeah.
we need to conduct. Anyone who wants to file a patent application, they might they might think like their idea is super because like it's their brain child, and they think like it is like world changing. But they need to understand whether this is already patented or whether someone already had a product of this thing, or someone had published this thing, so that like we may or he may not be eligible to get a patent. So to know that, so they have to opt for a patentability search either by themselves if they are trained, or maybe they got to know through other sources, maybe through some sort of a learning, or they can they can actually approach a patent agent or maybe a patent analyst for that fact.
Okay.
So they can actually have a patentability search uh, across the globe, because like trademarks examination, it is national. Copyrights, there is no examination, that is like they won't search for citations, copyright related works. Designs, again, though it is global, like the offices, like patent office in India or the design registry in India, they do search globally, but whether whatever the design been applied for, whether similar things are available in the web, and also they search in the Indian design registry.
Okay.
But for patents, it is a global search. The examiners will search, use databases like free databases as well, paid databases,
Okay.
and they try to search globally. But because it is required, it is mandated as per Patent Act. The patent applications need to be searched globally, and they fulfill the two criteria or three criteria we have:
Okay.
patentability, as well having an inventive step, and having an industrial application. If it is satisfying all these three criteria, and as per the Patent Act, it is sections 21J, patentability, that is eligibility for a patent.
Okay.
21JA, it is inventive step. Means it has an improvement when compared with the existing thing. And the other thing is industrial applicability. It should have an application, obviously. And there is another section, section 3. So which actually section 3 defines what cannot be patented, or certain things which cannot be patented. Like copyright matters are actually separately handled, like artistic or literature works can be only copyrighted.
Okay.
And that is also defined under section 3 in subsections.
Okay, sir.
So to summarize, the first step anyone, it's not only startup, anyone who wants to file a patent. So the first step is conducting a patentability search to determine if the invention is new and not obvious, and it has application. It can be used.
Okay.
As per sections 2 and 3 of Indian Patent Act 1970.
So if they find out that it's already been invented, it's already been disclosed, so their dreams cannot be moved forward, right? Like with respect to startup.
They can think of, like, it's a better thing. It's not only to yes or no. It's not like stopping or maybe go ahead. Not both. It is something like they can know where they stand, where their invention or maybe their idea stands, and they can work on improvements.
Okay.
They come to know what existing, what is there already till date, as on date.
Okay.
And then actually they can think of improving it with an expert help, with an patent agent's help. They can sit and they can think of some improvement which is not obvious again, which should be considered as an inventive step by patent office.
Okay.
So they make sure with the help of patent agent, and then they can proceed with the application filing. They may have an inferior version of product, or maybe the first version of what they thought as a product, by seeing freedom to operate in India. And then the next version could be the current version, which is improved as per the patent application, and that could be their second version or third version as a product.
Okay.
It is not, there is no condition that whatever been filed as a patent need to be developed as a product.
Okay. And
they can still operate,
yes,
operate on what is existing if it is not there in India. Means if no one has a patent right in India, for example, patent office will conduct a search and gives us citations from across the globe. They will give citation from China, or they will give citations from USA, Korea, Japan. So it means like that patent application or grant is there in Korea or Japan or in China, not in India.
Okay.
We need to check whether that person or that company has an right in India. If they don't have a right in India, and as well if they are not selling in India, exporting and selling in India, then we can develop that product here.
Okay.
But it is not safe. I mean, safe means like we can only sell it in India. We cannot sell it in Japan, or we cannot sell it in Korea. So that like we can first sell the product and then think of improving it, getting a patent here as well in other countries, so that they can sell the improved version in their second version or third version in India as well in other countries. So this is the main thing. This is the starting step, or maybe first step of planning to build or create an IP in terms of patent, and as well converting it as a product.
Yeah, and another typical question related to this question is, I mean, the first step again with respect to patent process for startups. The other day we were talking about Airbnb, the bread and breakfast, and there was a funny conversation with my son. The KFC, while we were going to the school, one morning again he said KFC is never open in the mornings. Why is it so? Because it's not Kentucky coffee, it's only chicken, and people don't prefer eating chicken early in the morning. But there was this Telangana tourism which launched this toddy store, or the palm tree leaves morning drink. Right?
Yes.
On Necklace Road. So I was wondering if then can be, I mean, if that process can be paid, if somebody comes up with normally when we go on a long drive, we see this toddy which is being sold early in the morning. for people
Yes.
who drink. They call it as a healthy drink in Kerala and other places also, which you might have seen. Can that process be a novel invention if somebody is offering like these other buffets in the afternoon or evening, like other brands? Can that process be patented with a new brand under trademark law or copyright law, sir?
Yeah, trademarks definitely. So I think like this is we are getting somewhat off bait from the topic, but still it is a relevant question. Yeah, for trademarking, it's a business name. So business name or product name can be trademarked.
Which
So
one?
if someone coming up with a unique way of launching toddy or toddy related product,
Toddy coffee. I don't think there is something
yeah.
like toddy coffee in the market because I love coffee, but it's a weird
That's fine.
combination, which people might hate it. But I mean, as no, I'm sure that I never heard about coffee with toddy or toddy
We
coffee.
saw, yeah, we saw in recent years, in last 3-4 years, like there are cafes with on the base material as base material from coconut.
Oh,
So they all actually named after coconut, like coconut farm or something like that. There are many brands.
oh, okay.
So we also filed one or two brand names, though they are very descriptive because the base thing is coconut. That means like they use coconut water and coconut fresh pulp to make different kinds of smoothies and juices.
Oh,
So
which
that
is
means like this junction or this cafe will have everything prepared with coconut as base.
cocoa coffee instead of water or
So
milk. Yeah.
yeah, instead of water as a base or instead of maybe milk as a base, they use coconut water and coconut milk and coconut fresh stock.
Wow.
So like that, yeah, someone may come in picture saying like I use instead of milk and maybe water, I use toddy as the base, and he can like come up with a unique name for his cafe, and he can definitely go with registering a trademark for it.
Yeah, we can.
If it is not descriptive, if it won't start with toddy, say like very generic toddy cave, so it cannot be toddy cave.
Yeah.
So it should be something else. It should be unique name, like maybe Jestro or Zomato or maybe Starbucks. It should be a unique one. Again, not conflicting Starbucks. We have an issue in hand. If I have reviewed that application before filing, I should have suggested not to file to our team. But somehow, like I cannot give a go ahead for every application. So this has been filed last month or maybe 40 days back, which is Chai Bucks.
Starbucks. Oh,
And
like
now in
Starbucks.
40 days, and he coined that logo as well in that circle. Like Starbucks will have in two circles,
They did
Starbucks
that.
written in
Okay.
that. So Chai Bucks. So in 40 days, we got a notice from SS Rana and Associates, which is which is top 5 trademark or IP attorneys firm.
Oh, God.
So who are actually representing Starbucks in India. So they sent a notice and asked to remove stop using as well, withdraw the application, withdraw the trademark application.
Oh, and I see they have a website also, chaibucks.co.in. So they can't continue with their business, or as a startups, they can't be successful or they can't scale.
No, these guys like Starbucks or KFC or maybe Coca-Cola, Facebook, these guys will be very, very affirmative. So within days, like they'll find if someone is using and trying to expand their thing, or maybe coming closer to or copying their brand, logo wise or maybe name wise or both. So they'll act very stringently. So like they sent a notice and they should have already prepared with the case to file in Delhi. Like they already had many like many orders in their favor in Delhi, because like they're a global player and they have 38,038. Yesterday, just I googled and saw. I mean, it's Charitesh actually, my son. When I'm just talking with Ma'am Brahmara, so he actually took my phone and he searched how many outlets does Starbucks have. So he's just telling me, showing me that 38,038 franchises they have in 84 countries.
Oh God.
And our person like Chai Bucks is having 8 franchises.
But legally, they will lose the battle. As a startup, they can't succeed with the brand name, right?
They cannot because like they are very close. And they tried copying Bucks definitely. So it's something like they coined after considering different names maybe, but they tried copying it. So it's evident.
What would be the solution, sir? Final solution for these guys?
They have to immediately remove all the digital content. They have to withdraw the trademark application. They have to give a declaration on if they want to play a very safe game, that is the solution. Or if they want to deny, and they have to face the consequences. Like in next, if they deny, like if you send a reply to the legal notice saying like we are denying all the charges, then in next 15 days we have to get a notice from or summons from court, High Court Delhi, saying like we are about to give an ad interim injunction on the matter, or if you want to contest, like you can come in couple of days and you can file your counter.
Okay. This is again a crazy startup story which I would like to explore. Let's see where that would go. So, how does a startup
This Bucks
find?
actually we had this previously also. One application maybe 2 years back or 3 years back. That also, I mean, the name is not Bucks or related to Starbucks, but the logo is similar.
They have a circular
Logo
logo
in the
with
sun, in that
India.
green and circle logo. Yes.
Yeah, and they have
Green
India,
color.
Indian map within it. And they say they are since doing it 1997. If I Google it,
Yes.
1997 to 2027 will be like almost 30 years. That'll be like too much of. I'm just waiting to see what will this happen in case if there is a legal battle, official battle between them.
Yeah.
So how does a startup file this provisional patent applications are in India?
Yeah, anyone who wants to file a patent application based on their idea, so they can first think of the search, and then if they are ready, I mean, with the consultation of a patent agent or a draftsman, the content, if it is sufficient to file a complete specification, it is always suggestible to file a complete specification and ask for a publication and ask for early examination if they are eligible, because like startups are eligible to ask for early examination. So startups, it is always suggestible if they have the information sufficient for filing a complete specification, it is always good they file a complete patent application. If not, like based on the suggestion of the agent, and they also feel if they haven't validated the implementation, I mean idea and its implementation, then that means like they don't have a prototype or they don't have a computer model to analyze using a software. Either of it they don't have, and it's something like it is the invention is speaking about some sort of efficiency, some sort of fuel efficiency, or some sort of related to its physical or chemical properties, like changing the physical or chemical properties of the output. Then in that case, so if it is water, it is definitely, I mean, the results are very much required. And if it is again a health supplement or maybe some sort of pharmaceutical compound and its process, again validation is required. And if it is related to energy efficiency or fuel efficiency, again results are required.
Okay.
So for some aspects, for example, if it is a computer related invention, then in that case, like there won't be any prototype or maybe required and give certain tests, standard tests. But we can build an application using some open software, open source, and then test the data integrity, safety, security based on the invention. I'm not specifically telling about one invention. If it is a computer related invention, yesterday we discussed about Flipkart having a patent. What is that? The other app, Myntra, having an having a feature which is patented.
Okay.
And Ola has, or Uber has certain features which are patented. For those things, it is not required that they have to show any tests, third-party test results. So in those cases, at least, so they can file directly the complete specification, complete application, and ask for early examination.
Okay.
And for certain other things like which we discussed now, for which are claiming energy efficiency or maybe water quality or something of that sort, which is speaking about physical or chemical properties of the output that the device is giving. Then in that case, like which are related to medical, etc. So those things, if they don't have results, then in that case, like it is suggestible they file a provisional specification, and within 12 months they have to fulfill the obligation of filing complete specification, and then they can ask for early publication and early examination.
Okay, so the question is again based on the same, I mean, the next follow-up would be the same. So when an individual files this applicant, again, what would be the price which he pays her, like for this provisional patent application, be it individual or small entity or anybody else in the startup?
Previously we have three categories: natural person, small entity, and other than natural person. Other than natural person means other than small entity, and other than natural person means which is a larger entity, not a small entity. That means like three categories. But now we have again three categories, but previously all these three categories have three different fees. That means like 1x for the natural person, 2x for I'll give the numbers, but 1x for the natural person, 2x for the small entity, and 4x for the normal entity.
Okay.
But now it is no 5x actually. So now it is 1x, either 1x or 5x. Now the natural person, small entity, or a startup, and as well an institution, government funded institution, or any other education institution which has a government approval, that is AICT approval. So all these four types of applicants: natural person, a small entity which is not a startup, but a startup as well, small entity, means all startups are automatically small entities.
Yeah.
Because the conditions are like that. So that means they are not bigger company, more than 50 crores of plant and machinery, and not bigger than 100 crores of turnover.
Okay.
So if it is less than 100 crores of turnover and less than 50 crores of plant and machinery, it is obviously a small entity, like eligible under Udyam registration, eligible for Udyam registration, and as well they are eligible for Startup India recognition. So all these three, natural persons, small entities, startups, as well institutions, are all categorized under 1x. That is, application fees is 1,600.
Okay.
Early publication fees is 2,500.
Okay.
And examination fees is 4,000. And early examination fees is an additional 4,000. That means like including all 12,100. So the government fee along with application for getting this application examined as early examination. So they have to pay 12,100, but only application fee. For example, they are filing a provisional application. Provisional applications cannot be published. Provisional applications cannot be taken for examination. In that case, like they will pay only the first fee. For filing the application, it is 1,600.
Okay.
And the other category, wherein previously there are three categories, now these are all in one category, which is 1x category. And other than all of these means like which is a normal entity or a larger entity, that applicant fees is 8,000. In place of 1,600, it is 5x.
Oh, this is again.
And even publication fee, examination fee also 5x.
Wow.
So instead of 2,500 early publication fee, It's the early publication fee for them is 12,500.
Yeah.
And the examination fee here it is 4,000. There it is 5 into 4,000. That is 20,000. And they are not eligible for early examination.
So, because they are again a small entity, or I mean, they are like others.
They are not
startups.
small entity. They
Yeah.
are a normal entity, bigger entity.
Bigger entity. Okay.
Previously, when institutions are categorized under normal entities,
Okay.
so that is the reason all the applications from institutions are used to be filed in the inventors' names only.
But now it's in
But
the
now, after the
colleges.
slashing of the prices, they are filing in institutions' names.
Yeah, mainly the colleges or universities. And
Yes.
good, awesome, sir. Thanks so much for these great insights. We'll continue with this series tomorrow with the rest of the questions. I mean, though we had a 30-minute time limit, we just crossed it by a couple of minutes, which is absolutely fine for now. This also reminds me of one of the medical devices lady who joined from Bangalore. Why people charge different fees for different, I mean, these numbers or statistics just reminded me of her conversation.
Yes.
But I'm sure you'll have thousands of examples like that. We'll tune in tomorrow again with other set of series of questions. For anybody catching the replay,
You can have same time, or maybe I mean we can schedule at 5:30.
Yeah.
So I think like it is more convenient.
Yeah, 5 or
to continue
5:30.
our series.
Yeah, 5 or 5:30.
Yeah.
I'll just schedule it, and probably let's go with 5. Let's see if anybody will hop in. Maybe see if they can get their questions
Yes.
answered. Like this other
Yes.
attorney or law. I mean, the lady who joined. Most of them do have the resources, but again, they need somebody whom they can lean back. Though they say salary is like a dopamine effect, or salary is a drug which people take, is what they say. But end of the day, with the knowledge which they already have, everybody can do things on their own, but they all need push. That's again with the startups, mainly startups needing funding, startups needing. There are so many examples which you can definitely give. How to monetize, or how to generate revenue, or how to get the series funding or seed funding. So we'll explore more, sir, for sure. And I'll schedule it for 5 p.m. for tomorrow. Let's see 5. And for anybody catching the replay, they can always tune into other episodes through Apple and Google Podcasts and explore other shorts which are there on YouTube platform as well. But we'll also, as you shared great insights from other apps, people also can see upcoming playlists under IAPR Society, which we have. I mean, the series of other insights from other questions also. We'll work on that, sir. Yeah. Thank you.
Thank you very much.
Srinivas, sir.
Yeah. Very good evening. Thank you.